Rules of Court, Rule 8.1115, Citation of Opinions. A. Unpublished opinion. Except as provided in B, an opinion of a California Court of Appeal or Superior Court Appellate Division that is not certified for publication or ordered published must not be cited or relied on by a court or a party in any other action. Hello, and welcome to Unpublished Opinions, a short-circuit podcast. This is the podcast where IJ attorneys get together and talk about things other than the federal courts of appeals, and we do it in a rather relaxed manner sometimes. Now, it has been some time since our last episode, as Captain Lawrence Oates might say, but there's a reason for that. So we're not on a schedule, so I'm not really apologizing that we didn't do an episode. We just kind of do them when we want to. But I wanted to have back on the panelists that we started our first episode with last summer, but they've been a little busy. One of them had a conversation with the members of the United States Supreme Court. The other was heavily involved in getting ready for that conversation. They also have other stuff going on, as you know, they do have clients and things like that. But now we finally have a moment of peace, and so I'm very happy to welcome back to Unpublished Opinions Anya Bidwell and Patrick Jaicomo. So, how are you two?
How are you, Patrick?
Oh, I'm doing great. I mean,
I'm doing all right.
Things are good. We had obviously a lot of work. I want to continue bearing the lead, I suppose. But it's always kind of out of the frying pan and into the fire. I feel like Anya and I have had like cycle after cycle for the last 5 years where we keep thinking like, okay, there's this big lead up to this big giant thing that's happening, and then it'll be over and we can relax. And then in reality, it just is like a resetting of another big thing starting again. So you just kind of get back. You just sort of get back on the roller coaster, I feel like.
But it's funny though, right? Because I feel like the universe is like assisting us, because when we have these prep cycles, like for the Supreme Court oral argument, we actually had a relatively quiet time in terms of potential cases coming our way or like other speaking engagements and those kinds of opportunities. And then essentially the second we're done with the oral argument, we have like a snowstorm of potential cases.
Well, it sounds like cosmically things kind of worked out then.
Yes.
So what they are alluding to, ladies and gentlemen, as many of you probably know, is the oral argument in Gonzalez versus Trevino that Anya argued on March 18th, I believe it was. So the first item we were thinking of talking about is, what was it like arguing before the U.S. Supreme Court? We, of course, don't, as of recording this on April 25th, we don't have the opinion in the case yet, so we don't know how it turned out. But we have the experience, and we also have the contrast of Anya's experience with Patrick's oral argument that he had at the U.S. Supreme Court a few terms ago, when he had to do it from a conference room because it was all during COVID. So unfair contrast, I know, but we can talk about two Supreme Court arguments, perhaps.
The universe strikes again.
Well, my argument was in person, and I felt like I benefited greatly from being there in person. The justices are so close to you. You really feel like you're having a conversation with them. And that really helps. I think with Patrick's argument, and I was there in that conference room, it was really, really hard to kind of just read where they were going with their questions, because you just couldn't see their faces. And I think that was a much harder thing to do, right, Pat?
Yeah, I think, so just to set the scene for everybody, it was COVID. And at the time, IJ was under construction. So that kind of added to the general look of everything. And there were a bunch of us that crowded into this one conference room. And if you've ever seen the sort of classic triangular conference room phone, that's what we were talking on. And we were in a conference room that happened to have a wall, with one of the walls being a whiteboard. And so I had just drawn 9 smiley faces on the wall so I would have something to look at, because I don't want to try to be looking at notes the whole time, but it's really strange. I mean, if you've never tried to do it, to have like a very intentional conversation when you don't have anything to fixate on with your eyeballs. And so you're just sort of talking at the wall and other people are in the room watching you do it. It was very strange. And it didn't have, like Anya said, when you're in the Supreme Court and, I get to sit there in the second chair watching Anya do her thing, you realize like, oh, these folks are close to me. They're also just human beings. But when you're in the conference room and all you have is your imagination, you can build it up to be more than it actually is when you're there to see it.
I can't agree more. It's this whole thing about, they're human beings, right? Like for us who do appellate law, they are like more than human. They're beings, they're human plus beings. Or at least that's how we kind of conceive of them before we actually see them in person. And then you're like, oh no, you're flesh and blood and I can totally engage with you in the argument and we can go back and forth and it will be just fine. But if you don't see them, if you're still listening to them, almost as if you're listening to an oh yes app on your phone, but you actually have to answer those questions, it's more intimidating. And the other thing too is, we argue in lower courts, right? In like the Fifth Circuit, the Eighth Circuit, the Seventh Circuit, the lower appellate courts. Those settings are almost more intimidating than the United States Supreme Court setting because the courtrooms are much larger, the judges are much farther from you, and there is like this echo and there's this intimidating distance between you and them, where you do feel like you kind of more doing a presentation than engaging in a conversation. With the Supreme Court justices and in that courtroom setting, you very much feel like you are having a conversation.
I feel that's very much just, I don't know if it's intentional or not. I mean, it must be specific to the U.S. Supreme Court building because like I've been at state Supreme Court arguments and I've been in a couple in Minnesota, and even there, you feel more removed. Like I remember in Minnesota, they have 7 justices. You feel fairly engaged with them and you're closer than a lot of like appellate courts. But even then, it's not the same as the U.S. Supreme Court, where like you could almost leap over the lectern and hit one of them.
I've been to the Nevada Supreme Court Supreme Court room, and I've been to the Texas Supreme Court room, and both of them are much more intimidating than the United States Supreme Court room. Not even close.
Oh yeah, Anya had an argument in the Eighth Circuit in St. Louis, and it was in their en banc courtroom, and it was just this massive courtroom, and she was probably like 20 feet further away from the panel than she was away from the Supreme Court.
Yeah, it's a different format, and you don't realize until you're actually there talking to them how intimate it is. And some people find it intimidating, but I think most people actually find it helpful.
Do you think it calms? So the advice you always get about oral arguments that all of us have gotten is try to have a conversation with these people. Yeah. And you're like, especially beforehand, you're like, conversation? I'm barely going to have time to put my argument out there. What do you I'm not asking them how the weather is. But once you're there, with that setting, did it kind of click in like, hey, we're just talking, or something close to that at least?
Yes, it definitely clicks in. And for all of those listening who will be doing their first Supreme Court arguments, what really helps is the day before to just go there and sit in that room and see them, ask their questions, do their thing, like really close in time to when you actually go. Because then you kind of get back into this sense of, oh, they're just normal human beings. They're having a conversation with the advocates. There's a completely normal human conversation. There's nothing crazy about it. Mm-hmm. And it really puts you in this right frame of mind.
So one thing I think both of you did, I didn't, maybe during COVID times, was do a appellate court argument with 3 judges, but on Zoom.
Yeah.
Which is, of course, not the same as in person, but it's also, it's not as like the way the Supreme Court did it was the most extremely impersonal with Patrick, because it wasn't Zoom, it was merely a phone call. So where does that like rank in the middle, doing the Zoom 3 judges?
That's a hard question. What
I
do you
don't
think,
know
Patrick?
I don't know that I did one. I don't think I did. I don't think I ever did a Zoom circuit argument.
I did one in the Fifth Circuit, and it just felt so strange. And it didn't feel, you weren't even sure if they were listening to you at all.
Yeah.
It was weird in the office because there were a few days during COVID where we had multiple people arguing in different circuit and district courts across the country, just like from across the hall, you know. And there were a couple times, I'm pretty sure, where there were more than one person arguing different courts at the same exact time. And so like on one side, there'd be like Andrew Ward arguing in the Ninth Circuit. And on the other side, it would be, you know, Bob McNamara in the Fourth.
That's kind of like, you know, like the old days. You're at the courthouse, you have paper thin walls, different judges hearing different things. You know, maybe it helps you relax a little.
What do you guys think about a mixed format, which is pretty common now in the circuit courts, where you have like 2 judges present and 1 appearing on Zoom? And they would even have, this is really weird, they would like have a TV screen instead of a person on that 3rd seat.
I think that was the worst of all worlds, honestly. and frankly, like I think it might work better if instead of the screen, they just had the person call in and like piped that into the courtroom, because then I think it's just, there's whatever the lag is, and it's not so much anymore. The technology is so good these days. There's enough of a lag that like it's kind of hard to break in, especially if you're one of the other judges on the panel. And I think, you know, even if it's very minor, the whole thing just gets thrown off by having like 1 or 2 of the judges showing up remotely.
So I was,
especially, yeah.
Well, I was at an argument in the 11th Circuit where one judge, for whatever reason, couldn't be there, and they didn't really say why. And the judge asked the questions over. It was not a screen; it was, you know, a phone call. And it was fine, and they were good questions, but they seemed engaged. But you know, it was kind of an afterthought, and so I guess it's better than nothing. You know, it's better than the judges participating on the briefs when you're like, for the advocate, that's pretty frustrating, because I mean, mostly because you don't have a preview of what the judge is thinking. And the judge is just going to decide the briefs. And for the judge, it's probably not a big deal, right? Because they always say, you know, oral argument is not quite as important as you think it is. You can rarely win an oral argument. You often can lose an oral argument. So maybe it's better the judge isn't there. But it still is, you know, it still is not great for the system, I think.
I think it gets really interesting when you have a contentious oral argument. We had one in the Fifth Circuit, where one judge appeared on Zoom and another judge appeared in person, and they disagreed with each other strongly. And it was really hard for the judge who appeared on Zoom to kind of read the cues, to know that, oh no, this other judge is really trying to jump in and has a question that would counteract his question. So that kind of dynamic where you actually have a disagreement between one who is remote and one who is in person is a very, very difficult dynamic. I'm not sure it happens very often, but it did happen with us, and it was very awkward.
Which brings us back, I think, to the wisdom of the way that the Chief Justice Roberts ran oral argument during COVID.
Kiss ass.
For those of you who don't know, during that time, they switched the format from the sort of free for all that had existed previously to the chief would just go basically 2 or 3 minutes at a time in order of seniority down, ask, you know, Justice Thomas, do you have any questions, so on and so forth. And that tradition is now sticking around in the live oral arguments, because that's now how the questioning ends for all the advocates, basically, who are arguing in person. So you have the free-for-all, and then you have the, you know, at the very end, you just have the chief going and asking each justice, do you have any more questions? And it's making oral arguments quite a bit longer, but I actually think it's very nice, and it doesn't feel like there's any opportunity for filibustering the time away. and you get a chance to actually, finally answer questions that might have otherwise been hanging out there if they're put to you in the question time and things like that.
How did you like that, Anya? I mean, you knew it was coming, of course, but what did it allow you to do, not, made for?
Well, first of all, it made me much more amenable to the United States Solicitor General's ask to yield 5 minutes of my time. Then I was like, sure, you can have 5 minutes of my time. You can have 10 minutes of my time if you want. Because at the end of the day, you're there to answer the justices' questions. And when you have this seriatim format in the end, you feel like if there was somebody who wanted to ask a question, they will have an opportunity to do so. And if they don't want to ask a question, then fine, you don't have that lost opportunity. But there was always this worry with the old format that there will be a justice who had a question, wanted to ask it, but we ran out of time, and you no longer have that worry, and that's great. I think, it's been very, very, very helpful to have that.
Anything else surprise you, going through this process now? Whole Supreme Court thing?
Well, it's this term is just so crazy. You have all these extra Trump cases. And the docket is just so full with controversial decisions that you just worry that, your case, even though it's an important constitutional question, that they just have so many other things on their minds that they need to take care of. That's what I'm thinking about in terms of this term, that we were super thrilled to get the grant, but it does feel like case like ours gets drawn out. And Adam Liptak actually wrote about it after the homelessness case that the court heard this week, right? Where he said normally this would be a blockbuster case, but given all that's happening, it's something that people are not even paying attention to.
So I will say, the court has a lot of these cases that people are calling huge, blockbuster, whatever, and they're not that case, and not the case you're talking about. They're not the case that our colleague Bob McNamara argued that we won, by the way, 9-0. That's been disputed for some reason, but no, we won 9-0. But even so, it's not that many cases compared to what the court used to do. It's 60, or I don't know what the number is, but every year it gets less. And so it's like, of this stuff people are talking about, it seems like they are talking about things that seem very important or contested or whatever, but the total volume of work those people inside that building are doing is less than they used to. So anyway, maybe that's just, don't worry about it.
These days, they write concurrences and dissents.
Yeah, because they have time to do that.
Today, by the way, we're recording this on Thursday, April 25th. The court heard the last argument of the term.
So did you listen to that argument?
Yeah, I did.
I have not. I have not listened yet. Do we want a little preview for? This will go out in a few days. So, maybe everyone knows all about the Trump immunity argument at this point. But any first reflections?
First reflections is that it's not looking good for the DC circuit. That one way or another, even if the court rules for the government here against Trump, that it's going to change the DC Circuit's decision. It's not going to stand with the reasoning that it currently has.
And that will give more scope for immunity, or probably in the end?
That'll give more scope for immunity. I was unpleasantly surprised about how pro-immunity the justices were, and how all of a sudden they're like skeptical of prosecutors, Like in our case, we kept hearing, presumption of regularity, prosecutors, we're talking about separation of powers, the judiciary is not going to be second guessing the executive, and prosecutors are making all these high-level decisions. And all of a sudden, even the chief was like skeptical of prosecutors.
Well, some prosecutors are more equal than others, right?
Mm-hmm.
Yeah.
Some are less absolutely immune than others, I guess.
Sure. I mean, we'll see what happens, and the issue is different, but like, even in the court's decision in its Nixon versus Fitzgerald, which for those of you who don't know, qualified immunity was created in a case that was brought against Nixon aides, and there was a companion case against President Nixon himself. And in the case against Nixon, the Supreme Court gave the president absolute immunity for actions taken while he was the president. And the explanation for why was kind of like Nixon's statements in the Frost-Nixon interview, where he's just like, well, because he's the president. Like, where does it come from? It's like, well, he's like the big guy. He's the big guy. So you can't be messing with the big guy. And it's like, okay, great. This is what we're doing, I guess.
And by the way, yeah.
Well, to clarify for everyone, so that was a civil immunity case, so where there's a lawsuit filed, private lawsuit filed, and of course, what's going to the Supreme Court is criminal immunity from federal prosecution.
To essentially extend, whether to extend Nixon versus Fitzgerald,
right, and to give a little bit of credit to the Supreme Court in its creation of qualified immunity. Like many of the other cases where it has created some lesser immunity, it did this, I think, as a compromise, because what the Nixon aides in that case were arguing was that they should also get absolute immunity. And the court said, no, we're not going to give you that, but we'll give you qualified immunity. And now, 50 years later, it's metastasized into what it is today.
Right.
And somehow it gave comfort to the court that Trump's minions could still be sued, even if he is absolutely immune for criminal prosecution.
That was discussed today at the argument?
Yeah.
Okay.
That's one of the things that Justice Gorsuch asked about what would happen to the underlings. And the other interesting point was when Justice Kagan said, well, what if the president is selling nuclear secrets? Or what if the president is ordering a military coup? And essentially, the lawyer for Trump said, yeah, it's all good.
Well, from like a national policy perspective, I think the government and the courts would be very reluctant to allow there to be like potential criminal liability for doing government stuff, like prosecuting an illegal war, for instance. And that would be something that they would never touch. But, committing some sort of more pedestrian crime, like if a president robbed a bank or something, then that would be the real tough question.
Which seems like the big issue in this is all along has been the official acts thing.
Private acts versus public acts.
Right.
And it looked like there was some movement towards, what if we just remand and let lower courts decide, which are private acts, which are public acts, and then what do we do then with evidence about public acts? Do we allow that evidence to come in when we're talking about the private acts, or do we not?
Every case the court does something like that with, I think they should go back and revise how many decisions they actually issued and not count those. If your decision is not to decide, basically, like that doesn't count. Like, okay, now we're going from 61 to 58.
I completely agree with that.
Relatedly, I think it was the First Circuit recently, like in the last week or two, kind of tutted somebody who was trying to distinguish earlier binding case law by saying, like we have all done and will continue to do, this circuit has decided this issue, but it didn't consider, these cases, or it didn't look at this particular angle on the issue because of party presentation. And the First Circuit said, no, we've got this really strong rule of orderliness, and so what governs is the rule that we adopt, and it doesn't really matter how poorly that it was argued. This is going to be the binding rule in our circuit. To which I thought, well, if that's the rule, and if you're going to sort of jealously guard orderliness, then you should be a lot more willing to grant en banc review, because otherwise you just get whatever the first decision is. And so if the parties in that case or the panel was particularly weak on the issues, everybody else is just permanently stuck with it until you can sort of meet the, almost impossible bar of getting en banc review granted.
Well, you'll be happy to hear that both the government and the defendant agreed that Nixon versus Fitzgerald is a great case, and so is Harlow versus Fitzgerald. So
yeah, well, this is another thing that we could, probably talk about for a while. But the problem in this kind of case, right? So whether it's former president or whoever, is the Justice Department is looking over its shoulder to protect governmental immunities. It just doesn't want it applied in this particular defendant. And so it can't just say, yeah, all this immunity stuff is a bad idea, even if the individual attorneys perhaps think that. And I don't know, it really calls out for, like an amicus arguing. I'm sure there's all kinds of amicus briefs that have been filed, but, maybe even participate in an argument like this because that side of the story isn't being told.
Yeah, that's an interesting idea. That would be actually helpful.
Well, a lot of people think a new rule of the FTC is helpful, but maybe a lot of people don't. So, Anya, you wanted to talk a little FTC. We got this bulldog, Commissioner Linda Khan. They're coming out with all these, all this free trade, you might say, or maybe you wouldn't say, going on. So, tell us, to listeners who aren't familiar with it, the basic idea, and then we can see what's up with it.
Yeah, so it's about non-competes, right? And the way that FTC polices these kinds of things. Normally, if the FTC doesn't like something, it files a lawsuit, right, to try to enforce the law. Very rarely do you have something like a direct pronouncement saying, this shall no longer be done. That kind of reminds me more of the New Deal era.
Well, it does some rulemaking, right? The FTC, even today?
Some rulemaking, but this is the first time in 50 years where it done something this direct. Normally, it just sues rather than make this kind of pronouncements. And so they basically said, we decided that there is no such thing as non-competes anymore, except when it comes to executive level employees who can negotiate their own salaries. And that, I don't like non-competes. So I sympathize with that general, sentiment.
Same.
But on the other hand, I'm thinking, in California, for example, where I am, non-competes are illegal. And that's because the California government decided to do that. And it seems like it is maybe a thing that's better left for states to worry about rather than the federal government. And it really, really did strike me as one of the really broader things that are flying under radar that the Biden administration did. And that's the funny thing about flying under radar too, because Patrick is like, what are you talking about? It's blowing up all over Twitter.
Oh yeah, YouTube and Twitter have been aflame about non-competes.
Yeah, I don't do Twitter kind of thing. I'm more of a conventional, traditional newspapers types of person, and it really hasn't been covered nearly as widely. But Patrick, you can tell us more about what you are hearing and seeing on your platforms.
One of the big disappointments I've had is that I've seen a lot of people commenting on this, a lot of the Twitterati and the law Twitter folks, and I've yet to see anyone use the word blue pencil. And it's like that to me is like that's non-compete stuff right there. You're going to blue pencil this non-compete, which to Anya's point, you kind of have the process side of it, which is this something that the FTC should do? Sorry, FTCA. That's a whole different can of worms. Is this something the FTC should do, and should it do it this way, and so on and so forth? And I frankly, I generally share Anya's reactions to I don't know exactly how the law works, and I don't know the history of the FTC and all the rest of it, but my inclination is the same, which is the regulation of specific business contracts seems like something that's probably better left to the states. On the other hand, you've got the substance of non-competes. And, I share Anya's reaction to thinking non-competes generally are not great. And the reason that I say that is, I worked in private practice for 6 years and dealt with it quite a bit. And my takeaways from that were that, most of the time, non-competes were basically just put into contracts with knowledge, or at least, if you knew anything about non-competes, you should know that they would be completely unenforceable. And at best, there would be some sort of blue penciling where the court would say, okay, well, you can't prevent this person from working in this industry nationwide for the next 30 years, but we can blue pencil it to say they can't work in this county for the next 6 months. And so I think that's, I guess, a point in favor of Anya's position about local control, because you could have a state like California that's going to say no non-competes at all, and you could have a state like Indiana that might say like a non-compete can't last longer than this long unless, or that it can't have this geographic distance or whatever. That being said, like there's no question in my mind that this is an anti-competitive contract provision.
Right.
And of course, the other thing that stood out to me from my years litigating in business contracts was, well, of course, the little dirty secret that most of us lawyers know is that you cannot bind lawyers with non-competes. I'm not aware of any state that allows non-competes for lawyers because the theory is it's unethical because it effectively restricts the pool of people to whom someone could go for counsel who's looking for a lawyer. Of course, we're protecting the potential clients, not the lawyers. But, I guess my takeaway from that is not just, there's some hypocrisy in defending them as a general matter, but liking the fact that they don't apply to you as a lawyer. And there's another that's, well, our system's already set up in a way that restricts them in a bunch of ways. You can't apply them to lawyers, and every state that I'm aware of that allows them still is going to restrict them. So you couldn't say, here, sign this contract to work at my Wendy's, and you have to promise you'll never work anywhere on earth for the next 1,000 years. And so like somewhere between that and no non-competes is probably like a more ideal solution, and that I think augurs in favor of having more flexibility in the way this works.
Yeah, I think all of us at IJ and most people listening to this have a healthy dose of skepticism that this is, constitutionally permissible for the FTC to do, and then get to the statute, whether the statute that's been around since the 1930s like even allows for the FTC to do this.
By the way, there are already 2 lawsuits filed.
Yeah, right? and I think
as of this Wednesday,
they'll probably be quite successful. Whether if you're talking about a contract that's not an interstate commerce, as we think it should be understood, that this is a no-go at the outset. But putting all that aside and the powers of the FTC aside, federalism aside, whether non-competes are a good idea from, a libertarian point of view or free market point of view is less straightforward than one might think, than, from a purely, it's contract's a contract and you can be able to enter into whatever you want, and you're a fool if you sign that, but you signed it, so you can't compete for 1,000 years, and you have to work at Wendy's the rest of your life or whatever.
Yeah.
There are shades of gray there, and I think part of it is too that the states are very different in how they treat them, and so for people who have maybe moved from one state to another, they're sometimes caught off guard by that, which I guess that would, people would say, oh, that weighs in favor of nationalizing the issue of non-competes. Because I know that, I worked in Illinois, and I remember learning that non-competes, I worked as an attorney, that there's no blue penciling in Illinois, but you can get rid of a non-compete clause, so rescind. So it's like all or nothing. In the litigation. I guess there's a little bit of gray area, but so it's like, can I not work for 5 years, or I can go right now? It's not like the judge will say, okay, how about 6 months,
right?
Or whatever.
That severability thing.
Is Michigan more of a blue pencil place, Patrick, where you were talking about?
Yeah, Michigan would blue pencil it. It's funny because Rob Johnson, our IJ colleague, had a nice, very long. What's that? What do we call it?
He pays the $8 so he can type a little longer on Twitter.
Yeah, which normally I'm opposed to. Like, I think if you can't fit your tweet into the normal tweet box, it's probably too long for anyone who's on Twitter. But this was a good one from Rob, and he kind of explained, like, well, on the one hand, some libertarians think X, and on the other, some think Y, and then he sort of talked about the process issues. So, to my friends who take the, like, absolutist contract position, like, I understand where you're coming from, and freedom to contract is very important, but there's lots of things that, for policy reasons, over the last 100 or 2 or 3 or 500 years, the common law courts have said, well, you can't contract that. And like, this is why we no longer have, among other reasons, things like you signing an indenture and stuff like that. So there's a lot of policy things that you can't have contracts for. And, non-competes are already strange. Like Anthony said, it's going to depend from state to state. Like, whoa, do we blue pencil here? Or do we find this is against public policy and just strike the non-compete completely? And what happens when you have a non-compete that you entered into in Illinois and then you go into Indiana and so on and so forth? And so, again, some of this might augur in favor of the additional flexibility that you would have from not having the FTCA set a one rule for everyone. But, at the same time, I think that there's probably plenty of people who identify as lowercase l libertarians who would say, be surprised to learn about, click-through contracts and whatever they used to be called when you bought software on CDs. And you open the box and it's like, oh, by opening this box, you've agreed to all these terms, which of course you couldn't read because they were inside the box. And so what if those terms said that, like, you owed all of your income for the next 25 years to Microsoft? Like, so there are limits that already exist that, restrict exactly what you can put in contracts and what you can't. But I think that it's a more difficult issue than just saying like they're great or they're terrible.
And some of those restrictions in the common law have been part of the common law regarding non-competes for a long time. Now, it's not like there was an age where non-competes were always enforceable no matter how you drew them up. I mean, non-competes weren't a big thing for a long time, but they were for someone who was, a master and had an apprentice and did the same work and didn't want them competing against them the day after their apprenticeship end or whatever. And so
right.
it was managed.
And there's a practical angle to it as well. Like, sure, of course, if you don't like a contract, don't agree to it. Yes, of course. But at the same time, like, does an 18-year-old who's applying to work at Burger King have like enough knowledge of the way any of this works to understand that the potential impact this could have if it was enforceable? And of course, that's the other thing. Like I started out with saying, my frustration with the concept of non-competes is that they're often just used as a way to either bully people out of doing things that the law doesn't allow, or to generate lawfare, because you say, okay, well, I can put this non-compete in here, and if this person competes, then I can just sue them into the Stone Age. And, we see this too with like liquidated damages clauses and all sorts of other little contract tricks that you can cook up.
Little contract tricks.
Yeah, so my new book That's coming out in September.
I used to spend a lot of time collecting liquidated damages.
Did you?
The defendant was never very happy about it.
Yeah, the rule in Michigan was kind of complicated, but you basically had to justify like the need for the damages. You couldn't just say like and of course everybody would still put in their contracts, like if we'll have a liquidated damages clause, maybe we'll call it accelerated damages and say like, oh, this is we agree that this is my actual damages if you do this thing. But still, you'd go through the same process we're talking about, like with non-competes, where the court would be like, is that really damages? And how much of it should you get? And you just have this whole expensive process.
That's why Anthony Trollope hated lawyers. That's all I'm going to say.
A relative of mine who was doing our family tree had a theory that Anthony Trollope shopped at this business that the family ran in London because he lived in the same neighborhood. But
that's a good theory.
So they were law stationers, but anyway. So I was just going to say that there's a Judge Posner case. I don't know. It's like 20, 30 years old now, though, where he runs down that rule against liquidated damages and said that's an outmoded part of the common law, and damages are damages, and if you agree to liquidated damages, you got to pay them. So maybe we'll try to dig that out. We can put that in the show notes. So we had a couple other things we were maybe going to talk about. I'd love to run down the lawyer's edition but I'm curious what's on your minds first.
No, I like
Pat,
that.
We're going to talk about common law.
Let's talk about books.
I mean, this is like really inside baseball, but it's not just like people who practice the Supreme Court know about this, but a lot of lawyers would know about this. But the Supreme Court, there are like 3 different ways you can read Supreme Court opinions once they're kind of final and quote published. Mm-hmm. And one is the U.S. reports, which is what most people use. Then there's this lawyer's edition that always has like all these weird it's like got a lot more, I don't know, filler, it seems, head notes, stuff like that. And then there's the Supreme Court reporter that comes out like super fast. And it's just, like hot off the press kind of thing. And then there's even like that, the wire service or whatever that comes out a week later. And then, of course, there's the way that most people actually read it these days, which is you get the opinion the day it comes out. But then sometimes
you Google it.
Yeah. And sometimes that gets kind of, slightly edited down the road.
I think, though, I think you need to take one step further back and explain to people that historically, when the internet didn't exist, the way that you would look up court cases is these big books would get published. And Anthony's talking about the different series of publishers for books. And the Supreme Court had several. Most state courts have several. Most state courts have like their own state publication, which will be like, a number and then the abbreviation of their state and then another number. And then there will be these regional reporters that also publish them. And so it's this strange hodgepodge of actual books that basically nobody uses anymore, the physical books. Almost every lawyer is getting their cases by Westlaw or Lexis or some other digital database so like it's all strangely like a fiction that these things are actual books at all. And so the system is very strange.
But the weirdest part to me is that people still cite, so for Supreme Court cases, people still do the parallel citation where they cite all three reporters or the major reporters.
So I will say in Michigan, the style, at least last I looked, was still you were supposed to parallel cite all the reporters.
I read there was a reform to parallel citation, like literally maybe last week. Maybe it's the latest Blue Book.
That could be
I'm
right.
with Judge Posner on this. We talked about Posner before, but it's like, come on, man.
Yeah, it doesn't make sense.
Just have a site where you can find the damn thing.
Well, Michigan also takes all the periods out of the citations. So like no period after the V, no period after abbreviated words, no period after the reporter name, if there normally is one.
So my big question though is like, why do we still have a lawyer's edition? Like, I don't know. Maybe the people listening, work on the lawyer's edition and they'll be out of the job if I get your pain. But I've never known anyone to say, oh, I use the lawyer's edition, not the U.S. reports because of blah, blah, blah.
I mean, it seems like obvious that the preference is for the U.S. reports. That's the one where the abbreviation of the reporter is U.S. And then the problem with using that is that it takes years before the U.S. report actually gives you a citation.
But now they have those preview ones online, which look really weird. And they don't do them for all the cases, it seems.
This is inconsistent with Blue Book, but my preference has always been like you should use basically the hometown version of each court to the extent it exists. And so it's like if you're citing a Nebraska Supreme Court decision or a Michigan one, like it's just easy as you're reading a case and you're seeing the citations. Once you get past the original citation, which spells out what state or what court decided the case, in all the short cites, you're just using regional reporters. And so you might not know like, oh, is this the Nebraska Supreme Court saying this? Because it's not going to say NEB on there. Same thing with Michigan. So like I like US, of course, because that tells you that's the Supreme Court. And then if you're using state courts, if you have the citation with the state reporter, then it's easy as you're reading just to see where's this authority coming from, especially when you're talking about all these old cases from different states and you're citing common law stuff.
See, I like the West reporter because then at least there's multiple states in the same reporter. And you just put the name. You just got to remember to put the name of the state within the parentheses with the year.
Yeah, but if you go, so you cite one once and then you refer back to it later.
Yeah,
the reader has to remember like, was that a state Supreme Court? And which state was it from?
I see.
That's my complaint.
Yeah, I like the text neb.
Yeah, then exactly. It's like, oh, it says text right there, so I know what it is. Except sometimes you'll cite some British reporters with some weird style and it'll be like NC and you'll be like, oh, that's North Carolina. And I'd be like, actually, no, that means like something in Latin about the king.
Yeah, I don't get the British reporters. I've never sat down and tried to figure out. But every time I look up a British case, it seems like a different system. They just...
Oh, yeah, especially if you go back more than like 100 or 200 years. Well, it's the same thing with the Supreme Court because... Another feature is if you go back before 18 something, I can't remember. It's in the Blue Book. Forgive me, everyone. But there were all these private reporters who ran these companies. And so you'll see like 3 US parentheses 7 wall, and then it's the same page number. And that was kind of like the British system was the same, except there were way more discrepancies between reporters back in like 1675 like King's Bench decisions.
But I guess that kind of reminds me why I thought of this in the first place was you'll see these old cases where they'll have the U.S. reports, say a case from 1810, and then in parentheses you will put the person, the reporter's name. I mean, these are names that we've seen a million times in citations. I can't remember them off the top of my head. Is that so? When you were just doing your Supreme Court briefs, are you still required to put that format in there?
We still put that in there.
Yeah,
Whether or not we're required, I don't know, but we always put that in there.
The beauty of the Supreme Court, in a way, is that like there's sort of like these customs that you're sort of expected to follow if you want to demonstrate your sophistication. But also, like, because the people that are practicing in the Supreme Court are such nerds, they all have their own like very personal and strong feelings about stuff like this. And the court itself seems kind of indifferent. You know, it's funny, we were just kind of having a little internal debate because one of our colleagues put together a very nice brief and she adopted the Supreme Court's own style for designating circuit decisions. And so most times the Blue Book standard is you'd put, you know, fifth, sir, period, and then the period, and then the year. But what she did and what the Supreme Court does in most of its opinions, maybe all of them, is it just put CA5 and then the year. And so like, there's not like it's still kind of like weirdly the Wild West, and I think the Supreme Court just expects you're going to make it look nice and be consistent, and that's good enough. And that, frankly, should be how it is everywhere.
So that there's no actual Supreme Court rule that says counsel have to use the CA whatever.
Nope.
There's a Supreme Court style guide that it follows, but again, like it's herding cats. You've got these 9 people who have very strong opinions about this stuff, and so if one is writing, then they'll probably, I presume, have a little more prerogative to decide these sort of unimportant stylistic things. But then you've got the Solicitor General's own style guide, which of course departs from the Blue Book in a bunch of bizarre ways. Like, for instance, they don't italicize the V period between the parties. And so, you know, I adopt mostly that style. Other people depart from it more or less. It's I don't know. Why would anyone be listening to this?
I don't know. I'm really sorry for our younger law student audience because they're like, what the hell? What is this? I just Google things.
But the other thing is, and maybe Anthony, you might know more than I do, but like my understanding is that the Blue Book is basically written by a bunch of Harvard like 2Ls.
Yeah, I think they have a little supervision.
Yeah, but still, it's like
I think it's Yale and Columbia too, or something like that.
Either way, it's a bunch of people that have never practiced law at all. Probably have never actually written a real legal brief. You know, maybe written a practice brief in like a legal research and writing class, and they're the ones like deciding these. Like there's no right answer to these questions, which is of course why there are like what are we on the 23rd edition of the Blue Book at this point? 27th? I have no idea. But it just strikes me as kind of silly. And then, of course, the other thing is you've got different citation styles for whether you're writing a law review article or whether you're writing a legal brief.
Just be consistent. That's all. Be consistent and be accurate.
And whoever you are, we do love you, Blue Book editors. Please remember that.
You're great. We appreciate you toiling at this completely, unending and thankless task of making sure we have the best spiral-bound little handbook.
So, unless you have another issue you'd like to bring up, I thought maybe we'd close with magazine covers.
We were going to talk about FBI versus Pilker.
Let's do it. All right, so Anya, you want to talk about mootness?
Do I really want to talk about mootness?
I thought.
The Supreme Court talked about mootness, and it basically said just what we said before. But the case was, and actually Patrick and I listened to a live opinion announcement of it when we went there before our argument in Gonzales. The Supreme Court case is about placing individuals on the no-fly list. And after the guy was put on the no-fly list and then sued, the government promptly removed him from the no-fly list and basically said, we don't really have plans as far as we know on putting him back onto the no-fly list. So the case is moot. There's nothing to see here.
Let me say two things about this. One, in all these cases with the no-fly list, and there's plenty of other government lists and stuff where they do this, but the no-fly list is by far the most egregious. they first and foremost will refuse to tell you if you're even on the damn thing. And so you'll just like one day show up at the airport and be told you can't fly, and that'll just continue to happen. And this has been used to great effect by like the FBI and stuff to lean on people to be like, hey, if you inform on your friends, then we'll let you fly on airplanes again. And so it's really insidious and gross, and it's been used, largely in a racist and xenophobic way.
And it's like there's no due process rights basically because there's quote no right to fly. Is the argument,
right? And then you've got all these weird national security carve outs. And so what would happen is that you'd find out just from a bad experience, like, oh, I must be on the no-fly list.
And then you have to actually ask the government, is it true?
And then the government would write you a letter and say, we can neither confirm nor deny.
Nor deny, exactly. That's what happened to two of my clients, Antonia Nwaorie and Gerardo Serrano. Both of them got those letters. We can neither confirm nor deny that you're on the no-fly list.
Yeah, there's a phrase for that, the neither confirm nor deny. It was created to like respond to the existence of some top secret submarine or something.
This is talked about on
Glomar.
Yes, this is talked about on the short circuit we released today. So short circuit 321 with Michelle Paradis, who is a national security lawyer. So listeners, if you want to go back and hear the story, which involves Howard Hughes and a sub, you can go back and listen to that episode.
All right, I'm pretty happy with my recollection then. But in any case, so the point is like it's much more frustrating even than this ridiculous mootness thing. And so this has been going on for like decades, and the
it's
courts,
really the post 9/11 thing, right? When they're trying to force these folks to cooperate,
which is decades now.
Yes,
which is now decades.
And there's still people in Guantanamo Bay, by the way. And there's decades of the courts saying like, yeah, it's moot now. They took you off the no-fly list. And so that brings us up to this FBI versus Filker situation.
Yes, where the Supreme Court basically said that the government must show that this thing cannot reasonably be expected to recur. So the court really didn't make any news. It didn't really create new law. It didn't really expand in its prior precedent. It just said that the government did not meet the burden here to show that they're not going to put this guy on the no-fly list again. What's interesting to me, though, is that this person was subjected to constitutional violations that seem to be much worse than being put on the no-fly list, like being detained without due process for a very, very long period of time. But that's not what he's suing about. He's suing about specifically not being allowed not being allowed to essentially leave a country because he's on a no-fly list.
Well, what's really notable to me is that when this case was decided in the Ninth Circuit, I think, and the Ninth Circuit said, the Ninth Circuit agreed, like, oh yeah, you can't strategically moot these cases. Like we've gone too far now for you to say, no harm, no foul, we took you off the list. It's very much like, when you're a kid and like you play too rough with your little sister and you hurt her, and then she starts crying and you're like, shh, don't tell mom. It's okay. Let me get you here. You want this sucker? It's like the government will do that. It'll do all this bad stuff.
It sounds like you speak from personal experience, Ben.
No, it's just, I don't know. It's just a trope, right? This is not something I'm thinking specifically of. Love you, Maggie. But so it's gotten away with this forever and ever and ever. And some organizations, among them CARE, has been litigating this, ACLU, for all these years. And they've just kind of gotten used to fighting this fight over and over and over and over again. And so the Ninth Circuit finally came out the other way and said, like, no, it's too late. You can't get off the ride now, FBI. And
twice. It said it twice because the case came back to them twice on the same mootness issue, because the government then issued some sort of a memorandum / testimony, also not committing to anything, but at least it was an official statement of non-commitment. And the Ninth Circuit again said it's not enough, even though the district court both times said it is enough.
Which, by the way, the FBI tried to do in our U.S. private vaults case after oral argument went spectacularly poorly for them. And they tried to write this post-brief motion to be like, actually, we give up now, and you don't have to decide this in a way that would be bad for us trying to do it elsewhere. But anyway, so that was sort of the setting. And when the Supreme Court granted cert, again, I'll bring in my Twitter knowledge. Like a bunch of people who were at CARE and who were working on this case were like, oh no, we got this big win in the Ninth Circuit. Now the Supreme Court's going to steal it away from us. like we said, this has been something that's sort of uniformly gone in the government's favor for decades. And then the decision is 9-0 with the Supreme Court being like, well, of course you couldn't do this.
Right.
Why would you think you could do this? No. This is obvious. No, of course. No, 9-0. Thank you very much. And everybody's like, wait a minute. No. Like you've treated this with like twos. Like you need to say like, this has been a crazy issue and the government's really been winning and like stake something out. But the court's telling of the story is like, oh, no. Yeah, of course, this is simple. And all nine of us agree. And this should have never happened, as if it hasn't been happening for, like Anya said, 23 years now.
Well, a 9-0 win is a 9-0 win. And
yeah, Pat and I might have high-fived really quietly when
we
were
did.
sitting in the
I actually was worried that one of the marshals was going to come over there. They were watching Anya like a hawk.
I was leaning forward too much.
What I thought was, so this basically said what we at IJ argue all the time when the government tries to moot our cases. But what I thought was really surprising is they give the rule for voluntary cessation, and so when a party, so it doesn't have to be the government, a party gives up and tries to moot the case, even though it's not certain that it might arise again in the future, and then they say that much holds for government defendants no less than for private ones. And they cite a few cases that kind of talk about that, but they're maybe a little different context, or I think it's more explanatory, those cases. But I know a little bit about this issue because I helped with an amicus brief in a lower court about it. But there are lots of courts that have said, well, we give a little more deference to the government in these cases, like in state courts too, that have basically adopted the federal standard. And it's just, just one sentence. Yeah. So basically it nukes all those cases, at least in federal court, and the state ones are probably going to follow it. And yet you think there'd be kind of a bigger deal, but no.
No,
just put it out there.
Justice Gorsuch really writes in his, style of using this prose where it's very much like, it's very common sense. There's nothing special about this here. This is how it works. And like Patrick said, there is a bit of a cognitive dissonance because people have been fighting these cases forever. And it's been incredibly frustrating. And then the Supreme Court finally says something about it. And it's like, yeah, what's the big deal? Yeah.
So congratulations to CARE, because, not only did they win this case, but they have been fighting this fight for a long, long, long time and getting just like running into wall after wall after wall. And so like it's obviously an awesome thing to win after all that time, but it does feel like I feel like I'm crazy. It's like for the court to treat it this way, like it was just totally uncontroversial, just as like, no, it was very controversial. A lot of people probably yelled at CARE in courtrooms across America for a decade or two because they took this position. Now the Supreme Court is, taking and saying, oh yeah, it's not controversial at all. Of course, that's the rule. And by the way, of course, it should be the rule, and not just in a case like this. In all these cases where the government's engaged in gamesmanship by trying to moot cases, this is how they should be met.
Right. There's all kinds of cases like, for example, it was a different situation, but there was the campus protest case from Georgia a couple terms ago where I think a Christian group was protesting and a policy.
Oh, yeah, Uzig Bunam.
Yes, the name I cannot pronounce, either one, the plaintiff or defendant. That case.
Otherwise known as Justice Kagan asked about Taylor Swift case.
There's only one of those? Okay. And so that case came down the nominal damages, which said the case could continue, but it also had this component about whether the policy would come back or not. And so this case is going to be very helpful in cases like that and all kinds of other cases. One thing I did notice, though, in researching this issue, whenever that was, the voluntary cessation, is that most cases with the government do find that the whatever it is moot, that the policy has cessated, if that's a word. It's just they say we have to be, it has to be reasonably likely to not reoccur or whatever the standard is. And then they say, but they've met it here. And I wondered if I think there are when it isn't moot, the government's probably just smart enough often not to argue this because so that when they're actually published, it's where a plaintiff has been desperate for a ruling, even though it seems like the case isn't going to continue. But it's the more rare case where they're not smart enough to stop it, and I guess that's why it took this case where there is this policy that has such huge consequences, and that it seems just so desperate to kind of hang on to the secrecy behind it that got it to the Supreme Court.
And I also would like to know the general spirit of the government should be treated no different from private litigant.
Right.
Oh, yeah.
And if we could
He's
please
still my
apply
heart.
that to immunity doctrines too, that would be great.
Just in general.
Yeah, there's a few other issues we might want to add to that.
I say this a lot. Like I had a very impressive win record when I was in private practice, suing party against party in the private context. And for some reason, I just became a worse lawyer when the defendant was the government.
DC Air or something, I guess.
Well, there might be something to that.
All right, so I want to close out about magazine covers. I don't know if this will add much to people's knowledge, but so I have, I don't know, the last year or two just kind of been more appreciative of the whole idea of the kind of, what do you call them? Like general issue magazine. So they have like the review type of magazine, right? So you'll have stories on political stuff, cultural things, book reviews at the back, right? Maybe even if it's
the best of them.
What's that?
The New Yorker.
Okay, yeah,
The New Yorker.
Well, I was gonna, name New Yorker is one idea, and like New Yorker, maybe even a little poetry in the back or a short story.
Yeah.
I mean, the old days, a lot of them had that, but really just the New Yorker now. And so I would extend this to, kind of more run-of-the-mill magazines like The Economist. Like I get The Economist, and the coolest issue of the year is the Christmas issue, the double issue that has all these crazy off-the-wall stories that, you can tell the writers have been saving up all year long. It has nothing to do with anything relevant today. It's just like this quirky story from, 1832 in South America or whatever. And they always do such a good job on the cover. So it's like you'll have all these names. Ooh, I like that writer. Ooh, I like that writer. And then you'll have this on this, and then this issue and this issue, and they'll always say, and more! Exclamation point. Like a good magazine cover always has the and more. And actually, maybe there's like one other story that they don't preview, but it makes you say, and more. So then you open it. And, this could be all kinds of, we could name drop a number of different magazines that used to do this. So they're rare today, unfortunately, right? But I think I'm coming around to their value. So then you open it up and maybe it's not as super interesting as you were hoping or the cover made it out to be. But nevertheless, the next time you see one, you still have that endorphins that hit you when you see that cover. So that,
man, I don't know. The only magazines I read are Reason, Liberty and Law, and the kind that you can buy a hovercraft through mail order in the back of the magazine.
So I should clarify, not all magazines do that. Now, Reason can do a great job with its covers. So I don't want to put our friends at Reason down. But some magazines are like, I don't know, Popular Mechanics or whatever. It's not that. It's kind of like, it's the type of magazine, the review type of magazine that holds all the arts and the culture and all that. Something about that mix and a well done cover just really pulls you in, right? So that, that's a marketing thing. That's like layout people know how to do that. Is there something lawyers can learn? You can't do that with a brief in most courts, unfortunately. Put in some graphics and exclamation points on the front cover. You would get your brief thrown out, unfortunately. But whether how you structure your roadmap or, more if it's like maybe legal publishing, there should be more of that, like a law review. What's wrong with a law review? Doing that on its cover. Not that anyone picks up physical law reviews anymore. But I wonder if there's something about that spirit that can make a stuffy, stodgy legal argument or legal practice kind of sing more, and a judge or a reader would be impressed by that.
I don't think this is particularly analogous to what you're describing, but like I'm a big fan of when they make sense putting pictures in briefs.
Yeah, no, I
Or
think this
mugshots.
is a bit of that.
Or
yeah.
what? Or mugshots, yeah.
mugshots.
Well, that's a
We
type
put
of picture.
Sylvia's, yes. We
Yeah.
put Sylvia's mugshot, and that's what I was thinking too. We put Sylvia Gonzalez's mugshot in both our petition and
Right.
our brief.
Another thing too, I
Yeah.
think is can be useful is if you've got videos and you want the court to read them. If you have like a representative screenshot of the video and you put that in the brief, I think it'll make them more likely to click on the link to watch the video.
And there's
But
a
as far as
video
just,
in Gonzalez, right?
Yes.
Yes. I do think, we did. I mean, we did pictures in the King briefing too. I don't think
Yep.
we had videos. Maybe we did. No, we did. We had the video of like the aftermath and that lady saying
Officer
they were
Allen, right?
killing him.
They're killing him. That's
Yeah.
right. Yeah.
Yeah, sorry, I'm being a little glib. But yeah, I think that's helpful as far as writing goes. Then we're just talking about like writing techniques to like grab someone's attention in the first sentence, which, there's a lot of good tactics you can use for that, but I don't think any of them are quite as cool as like the "and more" on the front of the magazine, because you're definitely limited in what you can put on the front of the brief in the caption and stuff.
Yeah, it's definitely just about being able to effectively communicate. And I think a lot of younger lawyers feel like the more legalese they use, the more serious
Right.
they sound. But in fact, the shorter the sentences, the more straightforward the structure, the more repetitive, frankly, the brief is in terms of the things that you want to emphasize, the more effective it is. We've been switching lately because of our colleague Marie Miller to this style of actually when we're writing a brief, we say we, right? Like we are going to explain to you this. And as we say previously, and she borrowed it from Chief Justice Roberts
Now he's
when he
kissing
was
up.
writing. He was writing his briefs, and it does read much easier. And it is very effective.
Don't most brief writers use we? Like
think
no one
you-
uses
ano-
I.
No, another technique is you say like Mr. Jones
Yeah, usually
will
you
show.
don't. Usually you don't say we or I.
this brief.
You just kind of write about it in third person. We is writing about it in first person, and
is.
that's something that I don't see done at all, and I think it's very effective.
Wait, but I agree with Anya. I am thinking, Anthony, to get to your like, what will make your case stand out like Bat Boy at the checkout counter?
Yeah.
And I think the closest analogy I can draw is if you're in the circuit court or the Supreme Court. You know what? Let's just do it at every court. I think they'd love it. You do the court name in a fancy old English font.
Yes, there you go.
And you use like a small font for the and then for the name of the court you get real big. I think like they think that's cool. They're like, yeah, this seems like I'm special now.
There are rules even for, the font on a cover though.
Yeah, that's true. You might have to roll the dice.
Push the envelope a little bit.
Yeah, what do you put in your like in your certificate of compliance at the end? It's like this very dryly like this brief was assembled in a Microsoft Word 2017 edition in 14-point font of Times New Roman, and then parentheses like except the awesome description of the court's name, which I put in like 65 font old English MT.
All right. Well, there's a tip for the practitioners out there. Much appreciated.
Here to help.
Well, we will be back with another unpublished opinions at an undisclosed time when we're ready to not publish. But for now, this has been a great conversation. Thank you two for coming on. And in the meantime, that's just like your unpublished opinion, man.
Yeah.
I'm gonna do like a gentleman, going